morning, everyone, and thank you for joining us for today's session. Today, we're going to examine the issues generated by Bank of New York Mellon and Cine UK Limited, and looking at the significant implications for commercial property lawyers acting for both landlords and tenants. I'm delighted to be joined, as always, by our regular speaker, Ian Quayle, and also Tim Calland of Maitland Chambers, who represented one of the parties in the recent summary judgment application. Good morning to you both.
Morning.
Before I hand over to Ian and Tim, I'd just like to go over a few items so you know how to participate in today's event. You're listening by default through your computer speaker system. If you would prefer to join over the telephone, you can just select the telephone option in your control panel and the dial-in information will be displayed. The reception over the telephone is very good and it is toll-free as well, so there's no cost there. You will have the opportunity to submit text questions throughout the presentation today to Ian and Tim by typing your questions into the questions pane of the control panel. We will have a designated Q&A session at the end of today's presentation, so please don't be alarmed if we're not answering the questions straight away. You can also raise your hand during the presentation if you're having any difficulties with sound or other technical issues, and we can try and resolve those. Also, if you would like to raise your hand and actually ask a question directly, please let me know. Please let me know in the chat function or via a question that you'd like to speak to us directly, and we can unmute you and allow you to speak to Ian and Tim. Finally, we've included the notes for today's session in the notes section of your control panel. You can access these via the handouts tab, but again, please do get in touch if you're having any issues accessing these. I'll be happy to sort that out for you. Anyway, that's enough from me, so I'll pass over to Ian and Tim for the main part of the presentation. Thank you, guys.
Thank you, Steve, and welcome everybody to this webinar. I'm delighted to introduce Tim Calland from Maitland Chambers, who's going to assist us with regard to this very interesting case, the Bank of New York, in the UK and others, which I think was heard towards the end of April, wasn't it, Tim?
No, judgment came out just a few weeks ago, but it was heard over 4 days in November and December last year.
Right. So judgment in April. So yeah, that's fine. So thanks, Tim. What I intend to do today is to ask Tim a lot of questions about the case and to enable Tim to sort of shed some light on some of the issues and decisions, looking at it from a transactional lawyer's perspective. I've provided some notes which really is sort of background to some of the issues that Tim and I will be discussing. And as I say, there is an opportunity for questions as we progress. There is a chat facility, and again, if there are questions that you want to raise but you're too shy to generate during the course of the presentation, then do feel free to email either Stuart Title or myself, and we'll endeavour to provide answers and solutions to any of the questions that you generate. So I really do appreciate your time, Tim, today. As far as some questions are concerned, first of all, the case was a summary judgment application, but having read the over 100 pages, wasn't it, Tim, of the judgment? Yeah, I'm delighted to say that it generates a number of issues that I think are really important for commercial property lawyers, be it doing landlord work or tenant work, acting for blue chip landlords or tenants, or high street retailers and smaller tenants. I think it has applicability across the whole spectrum. Would you agree with that, Tim?
Yes. I mean, really, what the case was about was about liability for rent during periods of lockdown, and it looked in particular at retail and leisure tenants, or tenants of retail and leisure premises, so those that were most affected by the lockdown. So it is a broad application, but it's most applicable to those tenants whose use of their premises was either prevented entirely or substantially curtailed by the effect of lockdown.
Yeah.
And I was just going to say, obviously going forward, at the moment, it looks like the issues in the case are going to be really of importance in relation to historic arrears of rent that may have built up over the last year or so, something which will become more of an urgent issue as the various moratoria are lifted in June, at the end of June. But also, we don't know with the new Indian variant out and about, and nobody knows whether there will be further lockdowns. So it's an issue of continuing interest, I think.
Yeah, absolutely. And I think the other thing, Tim, that's quite interesting is that from a draftsman's perspective, there are some interesting points that are worthy of consideration, which we'll come on to a little later today. But certainly, again, as far as this slide is concerned, is that in essence really what the court was exploring? Rent cessor, the idea of implied terms and frustration were the sort of main themes of the arguments being put forward by tenants.
Exactly. So the hearing itself was a hearing of 3 separate claims, and the tenants in each claim were running a slightly different argument. And Master Dagnall in the Queen's Bench Division thought it'd be sensible to run the cases together, so any overlapping issues could be dealt with at the same time. But the broad bases covered were the effect. The meaning and effect of the rent cessor or rent suspension provisions, whether any term could be implied about the obligation to pay rent abating while the premises can't be used, and then questions around frustration, both whether the leases could be treated as at an end because of frustration, which is the usual effect of frustration, or whether there was some type of suspensory consequence that's similar to frustration that suspends the obligation to perform the covenant to pay the rent during the period when the property can't be occupied. So those were the issues. And I think the headline result for anyone who's not heard it is that the tenants lost. But I think one of the big takeaways is that these points, or at least some of them, remain available in the right case. And so as landlords and tenants look to the next few months and what happens when the various moratoria come to an end, it does represent something of a grey area. Now, obviously, those representing landlords will say that this case and a similar case which came out just a few days before it, called Comets Real and TFS, that those 2 cases effectively settle the issue. Tenants will say, no, they were only decisions at the lowest level, and the issues are issues that deserve consideration at a higher level, and indeed they may well receive consideration at a higher level within those cases, because there's still the outstanding questions for permission, questions of permission to appeal and so on in those 2 cases. So it's very much a grey area.
Yeah, Tim, can I just ask a question there? So I think the important thing is, from a landlord's perspective, this is great news. From a tenant's perspective, at first blush, you think, crikey, this is bad news. But as you rightly say, firstly, there are certainly grey areas with regard to negotiation. So if I'm acting for a tenant and I'm negotiating with a landlord that's playing hardball, and the landlord is basically saying, well, this is the law, that's it, sorry, but I'm not doing any deals with you, there are some sort of shafts of light with regard to this case that certainly give you an opportunity to say, well, it's not quite as clear cut as that. And secondly, potentially there are still, hopefully, decisions of the court that may clarify some of those areas of light that I mentioned, and therefore it's not all over yet. Is that a fair summary of your sort of information?
I think what we can take from these decisions and the obvious focus on the different range of arguments is that the arguments will remain available really in the right cases. And so what we can take out of the decision in relation to rent cessor is that it all depends on what insurance the landlord has for the argument to work. So just to set out the basic scheme of the argument, as I'm sure everyone is aware, in a lease you'll typically have an obligation on the landlord to insure against various defined insured risks, usually with a power for the landlord to insure against such other risks as it acting reasonably thinks fit. And then we have the rent suspension clause, which will suspend the obligation to pay rent if the premises become destroyed or damaged by reason of any of the insured risks. Now, what the argument was in the Bank of New York cases was that the landlord had actually gone out and arranged insurance against its own losses in the event of a pandemic. And it had arranged that under the lease, and it had charged the tenants for the premium. And so the tenant said, well, that's an insured risk. And the insurance would only ever pay out if the landlord suffered a loss as a result of the insured risk. And the landlord would only suffer a loss if the rent cessor, the rent suspension, kicked in. So the tenant said, well, it's pretty reasonable to conclude that the rent cessor is intended to kick in the event of a pandemic. The difficulty was that the rent cessor provision was in a standard form, which usually has the words "if in the event of the premises being destroyed or damaged."
Yes.
Which obviously the natural meaning of that, I think everyone would immediately grasp, is physical damage.
Yes.
And so the landlord said, well, it doesn't kick in because the premises weren't physically damaged by the pandemic. The tenant said, well, you need to read the rent suspension provision to match the insurance that the landlord has actually arranged under the lease. Otherwise, it's all a waste of time and a waste of money. And so the question was whether the meaning of damaged in the rent cessor provision could be slightly bent out of shape to make the landlord's insurance actually work. And so it was a fairly conventional argument between the natural meaning of words and business common sense. And the decision of the court was that the natural meaning prevailed. But the reason I'm running through the argument now is to illustrate that it really turns on the landlord having arranged the right type of insurance. And this is illustrated by the other case I mentioned, the Commerce Real case about the Westfield shopping centre, because in that case, the landlord didn't have the right type of insurance. And so the tenant was driven to argue that the landlord was in breach of some kind of implied obligation to insure against pandemics. And it won't surprise anyone to hear that the court was quite unimpressed with that. And Chief Master Marsh found it really quite easy to dispose of that argument. And then without that relevant insurance in place, then the rent setter argument doesn't really work. So the key takeaway, I think, is if you're wondering whether this argument has any legs at all, you need to check with the landlord what insurance they have. And so that's an example of what I mean about it being runnable in the right case. And then taking the frustration issues, the key point to take away is that there's no authority at all for a circumstance that prevents the use of the demised premises causing a suspension in the obligation to pay rent. And so you may think that Master Dagnall was perfectly right to dismiss that argument, and it's indeed hard to see how it could be articulated at a higher level. However, there is an opening where there is a lease with not much time left on the term, because the circumstances which are making the premises unusable are expected to persist for the rest of the term, or substantially the rest of the term. Then you're much more into conventional frustration type cases where the fundamental purpose of the arrangement, or the lease in this case, effectively has gone. And so the frustration argument will only really work if you don't have much time left on your term, or if you are on a periodic term that can be terminated fairly quickly, for example, holding over under the 1954 Act or something like that. So the key point, I think, is to identify whether you've got one of the situations where these arguments really are decently runnable.
Tim, can I just ask a question there on this issue of frustration? You've just alluded to 2 points that I mentioned in the notes. The idea that as far as frustration is concerned, there is certainly in this case, and certainly there has been in the past, this idea about the balancing exercise between remainder of term and likelihood of event sort of continuing. I suppose the problem with this is, with regard to COVID, we just don't know, as you mentioned in your introduction there, we don't really know what's around the corner with regard to future lockdowns or that sort of thing. So certainly it's an argument, isn't it? And I think the 54 Act point, the holding over point, is a good one as well. So whilst frustration on the peculiar facts of the cases that were before the court didn't succeed, it's not to say that they might not in the future. And therefore, I think the point to make from a practitioner's perspective is to have a look at each case on its own merits and just run through the sort of frustration argument, not the temporary frustration, but what I class as the old-fashioned classic interpretation of frustration. Have a look at that and just see, is it worth a run? Tim, can I just ask you a question again on this issue of frustration? That where you have a lease that has a sort of very restrictive user covenant and has a very restrictive alienation provision, I was reading somewhere that the argument is, well, that sort of lease has the better potential to be frustrated on the basis that the lease is very restrictive in its substance. Have you seen that argument, and have you looked at that argument?
Well, in fact, in the Bank of New York case, one of the cases, the case against Sports Direct, there was quite a bit of time spent arguing about frustration in relation to Sports Direct, and particularly examining the provisions of the lease and the user covenants, exactly for that purpose, where counsel for Sports Direct was really highlighting the very limited use that the premises could be put to, and how that was completely curtailed by the lockdown regulations. So I would certainly agree with you that if you have a lease with a very restrictive user clause and substantial restrictions on alienation, so there really isn't very much that the tenant can do with the lease if they can't actually operate their business from the premises, then it's a much better candidate for a frustration type argument. And as you've said, it's a sort of all the circumstances type of assessment for the court to judge whether the case has got over the line to establish frustration. And so those kind of factors are the kind of things that will push you closer to the line, if not themselves actually over it.
Yeah. Okay, thank you. And the other point, Tim, that I think with regard to frustration is you've got to be careful what you wish for, haven't you? Because if you're a tenant and your lease is frustrated, then that's it, isn't it? The lease comes to an end. It's not a question of it comes to an end with regard to the rent. It comes to an end fully.
Yes, well, exactly, and that's why I think it's important to decide whether your case is the right type of case for a frustration argument, because what I suspect many tenants who have been suffering during the lockdown actually want to do is they want to reduce their liabilities for rent. They want to push them off into the future so that they can be paid in a more manageable way, but they fundamentally want to continue to operate their business.
Absolutely.
And the argument that the lease is frustrated, well, that leaves the tenant without premises. Now, there may be reasons why they would want that. It could be that we see a falling market for these types of premises, and they think they'd be better off packing up and renting new premises, perhaps at a lower rent. But obviously that would come with all of the costs and inconvenience of setting up in new premises. So it's something to be careful what you wish for. I think you're absolutely right.
Okay. And the other point, Tim, with regard to frustration is the point you touched on earlier. The concept of temporary frustration on reading the judgment just didn't find favour at all. Is that a fair summary?
I think that's fair, yeah. probably most people wouldn't be surprised to hear that, because this idea of temporary suspension really is one that's not recognized in any of the legal texts or indeed in any of the cases, or it's not identified in that way. And so the particular tenant that was arguing that particular point was driven to finding analogous type situations in other cases that are really about other things. And so it was always a difficult argument to run, and it's not a great surprise, I don't think, to anyone that Master Dagnall wasn't willing to accept it.
Before we leave, sorry Tim, carry on. Carry on.
Well, I was just going to say it'd be interesting to see whether it is pursued as part of the appeal grounds if an appeal is given permission.
The point I was going to make with regard to this is, and I think it's important from a practitioner's perspective, is to just check if you're acting for a tenant, just what their objective is, just what are we trying to achieve here? You know, are we attempting to achieve some form of negotiated settlement? We stay in, but our rent becomes more affordable. We push it out into the future, or do we really want to actually frustrate the lease and move on elsewhere? So I think it's one of those things that you've got to sit down with the client at the start and say just what our game plan is if we're negotiating, because the danger is if we're using it in a negotiation point, but we don't really want to frustrate, what's the position where the landlord says, well, okay, let's, you know, I accept your arguments, let's frustrate it. And from a landlord's perspective, again, objective is important when we're negotiating. I always say to people, we talk about 54 Act stuff, any form of negotiation with regard to leases, you need to find out what the market is before you sort of embark on a course, be it a litigation course or a negotiation course. You know, from a landlord's perspective, I would play hardball with this tenant and the tenant leaves, or the argument of frustration is accepted, or we agree a surrender, or the tenant just says, I've had enough and goes into liquidation. What am I going to end up with? So I think from a practitioner's point, Tim, it's important just right at the start to think what's our end game, what's our strategy here, because sometimes, you know, you can negotiate and use an interesting legal argument, but at the end of the day, shoot yourself in the foot. Again, if you've got a comment with regard to that, that would be useful.
Yeah, I would entirely agree with that. And certainly my experience, and it's entirely anecdotal from speaking to solicitors, is that the cases in which these arguments have ended up arising, these arguments about rent setter and frustration and so on, they're really the exceptional cases where the landlords weren't willing to be reasonable and to give the tenants either time or a reduction in the rent or that kind of thing. So certainly the impression I get is that these cases that have come to court, and the Bank of New York case is simply the first one that got to court in any sort of big way. There's a whole string of them queued up in the courts waiting to be dealt with. But they're all cases where, for one reason or another, some kind of sensible accommodation couldn't be reached. And I think that illustrates that these arguments are deployed not really as the first step of a discussion. We don't have to pay our rent because blah blah blah. But it's really an attempt to stop landlords who are unwilling to negotiate, really ruining the whole of the tenant's business by taking action that is going to be harmful to the business's ability to find credit, those types of things. So it was really these arguments are deployed as a last resort rather than a first.
I was just going to mention that, Tim, really, in sort of military terms, it's a thought that these arguments are a redoubt, aren't they? They're sort of the last stand, really, from a tenant perspective. So we start off negotiating and hey, hey, Mr. Landlord, let's work this through together. Landlord plays hardball. We get the flavour of that from the landlord straight away. Right, let's get some ammunition together so that if the landlord is going to play hardball, at least we've got some arguments. That's really the point, isn't it, from a negotiated perspective? Yeah.
And there's, I mean, one of the things that's been happening parallel to these cases about coronavirus and rent is obviously there's been a huge number of CVAs of tenants, company voluntary arrangements, where a proposal is made to creditors that effectively restructures the company's debt. And for those that don't know, the thing about a company voluntary arrangement, just like an individual voluntary arrangement, is that when the creditors decide whether to accept it or not, there is a process by which the majority can bind the minority. And sometimes these arrangements are felt by landlords to be unfair, because they invariably, in the case of retailers, involve restructuring the rental obligations under the leases. And one of the things that landlords will have in the back of their mind is that if the tenant is driven to seek insolvency advice and to propose a CVA, the landlord might end up with revised terms being imposed on it effectively by the agreement of the other creditors. And you know, there's no conceptual limit to the changes to the lease obligations that can be imposed. And what we've seen recently is a challenge by landlords in the New Look CVA, which was fairly roundly rejected. And so landlords will have to be mindful of playing it carefully, I think, so that they don't drive a tenant into an arrangement like a CVA that the landlord may ultimately feel they're worse off under.
Yeah, I think, Tim, there's an article on that in today's Estates Gazette on the New Look CVA point. I think there is. I mean, and the other thing on that is I dealt with a matter a few years ago where, in essence, the landlord was just ambushed by other creditors. So you had the landlord being a sort of 10% creditor in connection with the tenant, 90% of trade creditors. The trade creditors wanted the tenant to continue and therefore impose the deal on the poor unfortunate landlord. You can argue, can't you, sort of unfair prejudice? But again, there's a cost issue, and you're not necessarily obliged to succeed if you do challenge. So you're quite right. This idea of a landlord sort of playing hardball with a tenant again has its dangers on the basis of let's go into a CVA, or even, Tim, let's just hang our boots up and go into liquidation and walk off into the sunset.
Yeah, absolutely.
So yeah, that's great. Thanks for that, Tim. Okay, so Tim, you talked to me when we were discussing what we're going to talk about today about this idea of implied suspension and partial favour of consideration arguments, and you had me dusting down my old contract law notes and looking at this. I thought this sounds rather interesting, and I was sort of delighted when he sent me a copy of the judgment to think, right, there's going to be something really meaty. You're going to disappoint me now, aren't you?
Yeah. The partial failure of consideration argument, I think, definitely falls into the same category as the partial frustration. It's not really supported by any authority, and really is a way of trying to put a legal characterization on a point about basic fairness. And I think those tenants that argued it found it sort of fairly difficult to substantiate as a prospective doctrine. And obviously, no one would be surprised to hear that it wasn't accepted by the master. As for the implied suspension, the argument there was put in two ways. The first way, which was probably the more attractive way, was an argument about an implied term if the court didn't find that the rent setter provision was broad enough to embrace non-physical damage to the premises.
Yeah.
And there was an argument that a term should be implied, that in effect there's another rent suspension, an implied rent suspension clause that covers insured losses of a non-physical nature. That didn't find favour. The other way that the argument was made was that there should generally be implied into the lease a rent suspension provision that kicks in when the premises become unusable. And I mean, you only have to say it to see the difficulty with the argument, and particularly that given that this is a professionally drawn lease, it's in pretty much standard terms, these leases, and they can contain lots of detailed provisions about the allocation of risk in the event of various things rendering the property unusable, through the rent suspension clause. So it's always going to be difficult to say that somewhere amongst all of this there's an obvious but unexpressed agreement that if the premises become unusable for any other reason, that the rental liability will be completely abated. So again, that was another argument that was always going to be difficult to run, and not to say it wasn't worth testing on the court, but again, I wonder if we'll see it in any grounds of appeal going forward.
So, but Tim, the interesting point there is, if you're drafting leases or advising a tenant, it's certainly worth putting into the mix, isn't it, when looking at heads of term for some form of suspension provision in the event of a repeat of lockdown, etc. That would be a sensible thing to at least ventilate, wouldn't it?
Yeah, I think this is going to be a really interesting issue for transactional lawyers going forward, because obviously everyone is now aware of this enormous, catastrophic risk that really I don't think anyone much thought about before. And so I imagine when heads of terms get discussed, this is going to be put on the table, and it's going to be really interesting to see how it's dealt with. Because no doubt landlords will say, well, we've been signing leases with you and with other tenants for very many years, and there is a standard way of allocating risk. And the landlord will also say to the tenant, if you're really worried about this, why don't you go and buy some business interruption insurance? Query whether that insurance will in fact be available in the way that it was before the pandemic, because I think a lot of insurers are smarting quite a lot with the business interruption claim that they're now receiving, and the Supreme Court recently decided, a lot of them are going to stand up. And so I imagine landlords would say, no, your problem. Tenants, no doubt, are going to point to the desirability for both landlord and tenant in spreading the risk. Because it doesn't help either of them if something like this occurs and the tenant goes into insolvency, and just at the time when the landlord needs premises tenanted with someone who is in principle at least likely to be able to pay the rent after the pandemic, or possibly able to pay the rent after the pandemic, they're just going to be left with empty premises. With tenants in liquidation, first thing the liquidator will do is disclaim the lease. And that's a headache. So I imagine tenants are going to present it that way. I mean, I'm sure others who do more transactional work than me will know far better. But it's certainly going to be something, I think, that will be discussed between parties. And one of the really interesting things that came out recently that caught my eye was a 1954 Act renewal case, again to do with the Westfield Shopping Centre, where the landlord had in fact agreed with the tenant, W.H. Smith, that there should be a clause dealing with the risk of pandemic. And in effect, it was agreed that if there were to be another pandemic in the future, there's an argument about precisely what the trigger would be, but in the event of a future pandemic, the rental obligation would abate by 50%. And this, I should stress, wasn't something that the court imposed. It was something that the landlord actually was willing to agree. And so if that sample of one means anything at all, it perhaps indicates that landlords, and perhaps certainly larger landlords, may take a pragmatic view on this. But of course, then it has a knock-on consequence, which is what effect ought that have on the rent?
Just like you mentioned that,
yeah. I mean, I had a valuer just the other day saying, possibly it could push the landlord's position on rent up by as much as 10%. Quite how you get to 10%, I don't know, given that the last time there was a pandemic of this scale, certainly in this country, it was 100 years ago or more. But you can see that being something to be discussed and argued about.
Yeah, absolutely. I was talking to a landlord on this very point yesterday, Tim, and that was the same thing. Yeah, I'm prepared to be accommodating with regard to what the tenant is saying, but if I'm sharing the downside, I want a bit of the upside, so I want more rent. Yeah, that was the argument. The figures weren't mentioned, but that was the sort of stance, which was quite interesting. Good, thanks for that, Tim. So can I just push on, Tim, and talk about the codes of practice? Because I think it's an interesting thing from a practitioner's perspective that, we're all aware of codes of practice, both the code 2020 code of practice generally in connection with business leases, and of course the code of practice with regard to circumstances relating to COVID. How was this argued before the court, Tim?
This didn't really take up very much time.
Okay.
This was, I think, what most lawyers would call a jury point. That was presented by one of the tenants' counsel just to see if it stuck, see if it had any appeal to the master, which it didn't. Effectively, it was a complaint that by bringing these proceedings, the landlords were not keeping to the spirit of the code of practice by being as accommodating as they reasonably can and negotiating extensions where possible. The key thought here is that the landlord thought they'd been perfectly reasonable by not suing earlier, and that's not an issue which, under the code of practice, the court's entitled to take a view on. So it formed, I think, part of the backdrop, which was put forward just to put the legal arguments in a certain context, but it didn't have any practical difference on the outcome of the case.
So Tim, really, what I can say there is a toothless tiger, isn't it? Really.
Say again.
I'm saying, really, it's a toothless tiger, isn't it? The code of practice. It's just like the old business lease code. I used to do some work for a landlord who, in all his literature and everything he ever sent out to tenants or prospective tenants, were code compliant, etc. And then used to draft leases that clearly weren't code compliant, and no one took umbrage, and someone once did. And again, no sanction available in connection with non-compliance. So it's interesting just to see what the court's attitude was. And the reason I mentioned it, and the reason I wanted to take your view on it, is that, when we've discussed other things in the past, you have sort of emphasized the point that, it's important to, when you're appearing in a court or indeed in a tribunal, to appear to be doing the right thing. And I just wondered whether, there was any sort of merit awarded on the basis that the code of practice had been complied with, or indeed any detriment as a consequence of non-compliance. But from what you're saying, it was really a non-argument, and the court didn't really find favour or disfavour, if that's the right word, with either of the parties for complying or not complying.
Exactly right. Yeah, I mean, I would agree with you that in many cases, and perhaps even most cases, there's two parallel arguments to be had between the parties. I mean, one is the argument about the the technical issues that the court has to decide.
Mhm.
And the parallel argument is appealing to the judge's instinctive sense of who should be winning this case.
Yes.
And the
Yeah.
two don't necessarily cover the same ground or follow
Yeah.
the same course. And really, I think that just illustrates why the code of practice came up. It was sort of put forward as a, look at these terrible landlords
Yes.
suing us when this is what parties are meant to be doing. Maybe Master Dagnall was particularly hard-hearted, but I don't think I would characterize it that way. I think he saw the point for what it was and realized it didn't really assist him in dealing with the really quite technical legal arguments that were being run about the effect of the lease.
Yeah, that follows. So really, all we can say is, well, yeah, all right, there's no harm in complying with the code of practice, but there's nothing we can take from these cases that says, hey, if you don't comply, you've got a problem, or if you do comply, you're going to win, which is sensible, isn't it, I suppose?
Yeah. One of the things I would say is that the impression I have, and I only see the cases that really come to litigation, so I don't have the whole view, but from talking to a lot of solicitors about this, the impression I have is that most parties are substantially complying or living up to the expectations of the code of practice.
Yes.
And one of the really surprising things is actually how few cases there are before the courts, given the proportion of tenants up and down the country who haven't been paying their rents.
Yeah.
And so I mean, I heard someone say the other day that by their estimation in the retail and leisure sector, about a third of rent up and down the country has not been paid over the period since the beginning of the pandemic. And in any other circumstance, you'd expect there to be an absolute flood of claims. But one of the surprising things is how few such claims there have been. And you can see that from the fact that there's only two decisions to come from the courts, the Comments Real one and the Bank of New York one.
Yeah. I mean, part of that could be that, just as tenants in the retail and leisure sector are taking the hit, if a landlord is letting in that sector, again, they're hurting as well, I suppose. And again, may not have the appetite to litigate. So, it's a source for the goose, source for the gander there, isn't it? So let's do a bit of crystal ball gazing if we can. Obviously, we've got the end of the moratoria occurring shortly. And again, do you think we're going to see an avalanche of litigation, or do you think we're going to see people take a step back and say, let's negotiate and be sensible? I mentioned on slide here this thing about, I always look at landlord and tenant work and say the key is what a market condition is going to be like. And it's only when you can see what that position is, can you then decide what landlords or tenants are going to do. So as you alluded to a little earlier, if market conditions all of a sudden are buoyant and the world is back to normal, COVID under control and life is good, then we might see a radically different position to what I think is more likely going to be the case, that certainly from a retail perspective and from a sort of leisure perspective, the world might have changed a bit, therefore the market has changed a lot, and therefore neither landlords or tenants are going to be particularly aggressive, and they're just going to sort of reposition themselves to try and make the best of what I would potentially perceive as a bad job. What's your view?
I would agree with that. I think the first point to make is that the actions which are going to become available to landlords again, forfeiture, winding up, and CRA. And so each of those in their different ways is extremely harmful to the tenant. And I mean, just to pick up on CRA, I mean, if you've got a retail or leisure operator and you go in and you take all their stuff,
thank you.
That's going to seriously affect their ability to continue trading. And so given that the options that are becoming available to landlords again are each of them fairly nuclear options. I can't imagine that landlords are going to be too enthusiastic about the thought of actually exercising those rights until they know that there's another tenant queuing up to get into the premises. And so just like you say, it's all about market conditions. I mean, I can't see that the landlord's got anything to gain by forfeiting leases for rent arrears built up over the pandemic. If the effect is they're going to be left with empty premises, rates liability, you know, why on earth would they? But there are always outliers, though, and there are always unusual cases, and there's always parties who act irrationally. So I would expect that we will see a number of cases that will look at quite carefully, particularly winding up and relief from forfeiture. And it would be interesting to see if the court, for example, in relation to relief from forfeiture, approaches the question of relief any differently to the way it normally would in a rent arrears case, which is that you have to pay the arrears to get relief. It's really the kind of circumstance that tests that principle and to see how flexible it could be. In relation to winding up, haven't really thought about this in too much detail yet, but you can see there's going to be questions around solvency, what that specifically means in these unusual circumstances, and whether, to what extent, the court has any discretion to kick the can down the road and to see how things pan out in a few months. And certainly on the law as it stands, I mean, it's pretty clear what insolvency means for the purpose of a winding up petition, not paying your debts as they fall due. And the courts generally don't exercise any discretion, any flexibility in choosing not to wind up an insolvent company that hasn't got any good reason not to be wound up. But it'll be interesting to see what arguments are deployed there and whether they gain any traction.
I think that the key point here, Tim, that we discussed earlier is the point that, in essence, everyone acting for a landlord or a tenant has to look at the unique set of circumstances in connection with that particular transaction, that particular landlord and particular tenant, and adopt a strategy to suit. There isn't a sort of blanket approach that is going to be appropriate. And I think the other thing is that ensuring that if you're giving advice, you've got the whole picture. So you understand what your client's game plan is, what their objective is. You've got evidence as to what market conditions are like. And as a consequence of that, you're able to agree a strategy with your client that's going to hopefully generate the best result for them. As you say, the sort of nuclear option invariably is not going to be satisfactory unless you've got a queue of tenants sitting there who are all blue chip tenants who are all hot to trot with regard to a new lease.
Exactly right.
Yeah, thanks for that, Tim. So again, the next thing that I want to ask you about and for you to consider is when we're drafting leases or advising on leases in context of landlord or tenant, what do you think we can take away from what you've seen in these cases?
I think the key point is that the negotiating environment has changed substantially. I mean, obviously there's this new great risk that everyone is suddenly aware of, and probably never thought about before, and it has to be accommodated in one way or another, or perhaps not at all. And so there's a question about how to achieve that. And so, I mean, we've spoken about rent suspension. It may be that break options assume a bit more importance, even though they're probably likely to be less useful to tenants in a pandemic than a rent suspension. Turnover leases are an obvious thing to consider, setting rent by turnover.
Yeah.
I mean, it's obviously fairly unusual at the moment, and it's not all that attractive, certainly for the landlord. But it is one possible way of accommodating this risk within a traditional lease structure.
Yeah.
And one option might be to have, for example, a turnover rent that kicks in certain periods.
Yes.
I don't know. It would all be up for negotiation, and crucially, I think a huge amount will depend on the bargaining position.
Absolutely. Yeah. Tim, on the issue of turnover, I mean, I'm smiling as I talk about it. I spent a few years ago a lot of time looking at turnover leases. About the same time, I was looking at green and eco leases as well. And as far as turnover leases are concerned, you say from a landlord's perspective, they're not particularly attractive. From a tenant's perspective, they can be very unattractive on the basis that it's turnover, not profit. And I remember giving some advice to a firm of lawyers, advising a tenant who'd entered into a turnover lease that was very unsatisfactory for the tenant, on the basis that margins were decreasing due to market conditions, and yet landlord was still entitled to a percentage of turnover. But you're right, Tim, with regard to turnover leases, at least there is an apparent sort of sharing of risk, isn't there? A landlord offering that as a deal to say, look, I'm prepared to share the hurt that you might take as a consequence of problems arising, but as well as sort of sharing upside. So you're right, turnover leases aren't necessarily the fix or the solution, but they may be appropriate. And again, you're right, you're down to economic bargaining position, aren't you, of the parties' strengths and weaknesses. I mentioned just on this slide the idea of tenant-friendly leases, sort of easy out, easy in type of things, a sort of flexi-let, an easy lease that you see in connection with business startups. You might start to see that in the sort of retail or leisure sector as a means of just encouraging new tenants into the market and helping old. So yeah, I think it's interesting. The point that I just want to dwell on for a moment or two is the point that you touched on earlier about pandemic rent suspension affecting values. And again, I think that's important from a tenant's perspective, in that we may shoot ourselves in the foot with regard to insisting on that, and a landlord then saying, well, yeah, fine, but I want something else in return. Okay, Tim, that's brilliant. Tim, is there anything by way of summary that you want to share with us? Anything by way of conclusion? You did mention the suggestion of an appeal. Can you share anything with us on that front or not?
Well, in the Bank of New York case, there's a hearing coming up in June where the master will be considering applications for permission to appeal.
Right.
So obviously that's up in the air. If permission to appeal is refused, well, sought at first and then refused by the master, there's the possibility of seeking permission to appeal from the judge. So it's a process that might be drawn out over some months. I understand in the Comets Real case, Chief Master Marsh refused permission to appeal, but the tenant is renewing its application for permission to appeal to the judge. So again, we'll have to see what happens there. I think probably the key point is that nothing much is going to happen very quickly in relation to these appeals. I mean, it could well be the end of the year before any appeal is decided. And I suspect by then it will have started to become really substantially clear what the landscape is looking like.
Yes.
And so it may be that by then these issues just sort of recede into the background.
Drift off,
I mean, the biggest determinant, I think, of what everything's going to look like going forward is what the recovery from the whole pandemic situation looks like. If there's a massive 1920s style boom, then it'll probably look a lot like the market did before.
Yes.
Leases will substantially be the same as before, and so on. If, however, the economy is struggling or particular sectors are struggling, as you know, everyone expects to be the case with retail, then that could very well be a driver for change.
Yeah. All right, Tim, thank you very much indeed for your contribution today. It's been really, really interesting. What I'd like to do now, Steve, if I can, is ask if there are any questions with regard to Tim's comments and thoughts, any views, any opinions that any attendees would like to share, or anything else that arises, Steve.
Yeah, thanks, Ian, and thank you, Tim, for the presentation there. We have a few questions in. What I'd like to do, Ian, if that's okay, I think we should have a hard stop at 11 this morning, so I'll just ask one or two of these questions if we can get through them, but then take some offline, I think, after that.
Yeah, that'll be fine.
So,
yeah, of course.
Question from Joanna. Joanna asks, how will rent abatement provisions work with banking covenants that also constrain landlords who need to service their debts?
Well,
I don't know, Ian or Tim, you want to take that one?
I think that's a great question. I mean, that will be the limiting factor on what a landlord can negotiate, I think, because I mean, it's easy to think of landlords as, you know, the owners of property just with an income stream that can be bigger or smaller. But the reality, obviously, is that a majority of landlords operate on fairly tight margins and within tight funding constraints, and that will be a really big driver from the landlord's perspective.
Yeah, absolutely.
Yeah,
Ian, did you want to add anything there? Or?
No, just a really good question, and as Tim says, quite right. You know, that is going to be a sort of a major issue with the negotiation. You know, a lot of landlords aren't in a position where they can just say to a tenant, "Hey, what do you want?" There are constraints, and banking covenant being one of them. Great, good question.
Perfect. I just one final question. It's a question from Fiona. Fiona asks, is there an issue with solicitors getting involved with advice on market conditions whilst dealing with approving / amending a lease? Ian said need to consider this as well as client's game plan and the whole picture.
Yeah, I can answer that one, Tim, if you can assist in a moment. But my philosophy is that as a lawyer, you can't advise on market conditions. You advise your client to check the position with regard to market conditions and then get instructions from the client as to what they do. But I think it's important that you are aware of what market conditions are, particularly where you're dealing with unsophisticated clients. But certainly you wouldn't advise as to what the market conditions are or the implications of the conditions. Do you think that's fair comment, Tim? Perhaps I was sort of was wrong in suggesting or implying that the lawyer gave advice about market conditions and market forces. The point really that I should have made is it's a need for an awareness of market conditions as well as client objective.
Yeah, I couldn't agree more. I particularly agree with the proposition that professionals shouldn't advise outside their expertise. And if they do, they can expect trouble. Yeah,
absolutely. Yeah.
Perfect. But thank you both. I apologise to people that have sent questions in that we haven't got a chance to answer them. We will make a point of taking these offline and getting back to you and answering any questions you have. But thank you to everyone for attending. So just to wrap up, I'd just like to thank Ian as always, and thank you, Tim, for taking the time to speak with us today. Thank you again to all of you for attending. Just quickly, we have included some links in the chat section to our YouTube channel, our LinkedIn page, and also the LinkedIn pages for Tim and Ian if you'd like to connect with them. And please do give us a like or subscribe if you do follow these platforms or you would like to see previous webinars that we've held that have been recorded. If you do have any other questions, please do contact us. You will receive an automated message from GoToWebinar following the presentation today. If you respond to this email, the replies will come directly to me and I can send any questions or feedback on to Ian and Tim. You will also receive a separate email from my colleague Robert Kelly, which will contain the slides and notes and recording of today's session. So that just leaves me to say on behalf of Stuart Title, Ian Quayle, IQ Training, and Tim Calland of Bateman Chambers, thank you for joining us today and have a great rest of your day. Thanks everyone. Bye.